Good morning. I decided to go with the flow here and have a new gavel this morning. And those of you at the table, you know what this is, from a long wall scaling machine, and possibly a culprit in some past accidents, but also something that is causing great opportunity in our coal mining industry as well. So forgive me if I use this today. I just have to make sure I release it ever so slowly with the weights that's in it. A quorum being present, the committee will come to order. Good morning. I'd like to thank you all for joining us today and thank our witnesses for being here to continue a discussion on the health and the safety of American workers. Each day, men and women across this country work hard to earn a living and provide for their families. They deserve thanks for doing something they should do, but nonetheless, thanks as well. But they also deserve the security and peace of mind that come from knowing their workplaces are safe and that effective policies are in place to protect them. That's true whether an individual works at a desk, behind a counter, or in a mine. 2 weeks ago, we discussed the important role of the Occupational Safety and Health Administration and what it plays in that process in providing American workers the safe workplaces they deserve. And earlier this year, we heard from Assistant Secretary Joe Main, head of the Mine Safety and Health Administration, who discussed the work his agency is doing to help keep miners safe. On each occasion, we urge the administration to hold bad actors accountable, as well as to work with employers and other stakeholders to identify gaps in safety and to implement responsible solutions. The goal is to prevent injuries and fatalities before they occur, and this responsible approach is the best way to achieve that goal. Today, we'll hear from a number of stakeholders in the mining industry, including operators, labor, and safety experts. There have been significant changes in the mining industry over the last several years, including the way health and safety policies are enforced. This hearing is an opportunity to hear what's working and what isn't. As we all know, thousands of miners are employed by an industry that is vitally important to our nation's homes and businesses. Vitally important to our nation's homes and businesses, and I hope all levels of our governmental system hear that and acknowledge that. We also know that these men and women work in an environment that is extremely dangerous, where some of the most basic tasks can be life-threatening. It's hard to imagine working in a place where the very air you breathe is hazardous to your health. But that's just one of the many hazards miners face. We have witnessed the deadly consequences that ensue when mine safety and health rules are not followed. Upper Big Branch is a painful reminder of what happened when bad actors put profit before safety, and a trial currently underway in West Virginia demonstrates the role our criminal justice system can play. Upper Big Branch is also a painful reminder of what happens when mine safety and health rules are not properly enforced. As an independent report from National Institute for Occupational Safety and Health noted, and I quote, "If the Mine Safety and Health Administration had engaged in timely enforcement of the Mine Act and applicable standards and regulations, it would have lessened the chances of and possibly could have prevented the UBB explosion," end quote. In response, the agency has taken steps intended to improve safety, such as requiring the use of continuous personal dust monitors and proximity detectors, launching an impact inspection initiative, and changing the pattern of violations process. We have repeatedly called on MSHA to do better, and while we haven't agreed with each action it has taken, we are pleased the agency is showing more of a commitment to using the tools it has to keep miners safe. Unfortunately, along with reports of effective enforcement, I've also heard reports of inspectors being overly aggressive in their citation policy. With one inspector, the majority of citations were found to be in error by a court. We agree that oversight of mine safety is imperative to worker safety, but we also want to ensure mines can continue to successfully operate and provide good jobs and security for its workers. We look forward to hearing from our witnesses on these and other actions MSHA has taken in recent years. Understanding the state of the industry, seeing how current rules are not working, and discussing what we can do differently are vital to worker safety and job security. And that's why we've asked you all to join us today. Each of you offers a different and important perspective on the policies in place to protect America's miners. Your views and expertise will help us answer a number of important questions. Are the policies that have been put in place in recent years working? If not, why not? Is enforcement more effective or less effective? Are there additional steps MSHA can take to strengthen protections? Your testimonies will help us ensure enforcement and regulatory policies serve the best interests of miners and their families. Again, I thank you for joining us. We look forward to your testimony and to continuing this important conversation on worker safety. With that, I'll now recognize our ranking member, Ms. Wilson, for her opening remarks.
Thank you, Mr. Chair. I want to thank you for holding this hearing and giving us the opportunity to discuss how we can better protect the health and safety of miners. Our ranking member, Scott, I want to thank you also for being here. When we discuss the health of miners, we must discuss finding ways to end black lung disease and also to help those suffering from the disease secure the benefits they deserved. I was moved by the story of Steve Day, a miner featured in the Center for Public Integrity's Pulitzer Prize-winning investigation into the black lung benefit system. After 35 years working in coal mines and breathing in coal dust, Steve developed debilitating symptoms that made it impossible to perform even simple tasks. Instead, he was forced to spend his days sitting in a recliner next to the oxygen tank he relied on 24 hours a day. He was unable to even lie down to sleep next to his wife. To do so would overwhelm his lungs and leave him feeling as if he were suffocating. His wife slept restlessly in a nearby bedroom, jumping out of bed when he gasped for air and pounding him on the back until he coughed. I can only imagine the sleepless nights his wife spent, fearful that if she should close her eyes for only a moment, she would wake up to hear that he was not breathing at all. Steve represents the thousands of miners suffering from the debilitating disease that has killed 76,000 coal miners. Sadly, after years of decline, we have seen an alarming spike in the rate of black lung disease, including a 10-fold increase in the most severe forms of the disease. Black lung disease is entirely preventable. The MSHA's respirable dust rule will reduce miner exposure to coal dust. Starting February 2016, mine operators must use a continuous personal dust monitor. This tool will allow for real-time exposure information and give operators the ability to make the necessary adjustments to cut exposure faster. Beyond prevention, we must also ensure that miners who develop black lung disease get the benefits they deserve. Our committee has not had a hearing on the Black Lung Benefits Act in almost 25 years. So I'm glad for this opportunity to hear from our witnesses about challenges faced by black lung claimants. Steve Day's story underscores some of those challenges. Although he was clearly suffering from black lung, his former employer used biased medical reports that led to the denial of his benefits claim. Sadly, it wasn't until Steve died at 67 and an autopsy was performed that he was vindicated. According to experts, Steve suffered from one of the most severe cases of black lung they had ever seen. Miners with black lung disease fighting for their lives should not also have to fight against unfair tactics that needlessly delay or deny deserved benefits. That is why we must pass the Black Lung Benefits Improvement Act to provide minors with assistance in securing medical evidence and obtaining legal representation. Of course, we know that all mines are not coal mines. Today, we will also hear about safety issues in metal and non-metal mines. Last year, fatalities in metal, non-metal mines reached a 7-year high. This reminds us that we must ensure that we have the tools we need to protect miners' safety. As we discussed in our April hearing, the Robert C. Byrd Mine Safety Protection Act provides those much-needed tools. I want to thank our witnesses for being here today. I look forward to your testimony, and I yield back.
I thank the gentlelady. Pursuant to Committee Rule 7C, all subcommittee members will be permitted to submit written statements to be included in the permanent hearing record, and without objection, the hearing record will remain open for 14 days to allow statements, questions for the record, and other extraneous material referenced during the hearing to be submitted in the official hearing record. It's now my pleasure to introduce today's witnesses. The first witness, Jeffrey L. Kohler, Ph.D., is a professor and the George H. and Ann B. Dyke Endowed Chair in Mining Engineering at Penn State University. Good Big Ten school. Dr. Kohler recently retired from the National Institute for Occupational Safety and Health as the Associate Director for Mining, Office of Mine Safety and Health Research. Mr. Kohler teaches mining engineering courses and has conducted research in several areas, including electrical systems, materials handling, ventilation, quarry engineering, and mining methods. Welcome. Steve Sanders is Director for the Appalachian Citizens. Is it Appalachian or Appalachian? Okay, I want to make sure I do it right. I'm just a Yankee. Appalachian Citizens Law Center. Mr. Sanders founded ACLC, an organization representing coal miners and their families on issues of black lung and mine safety, in 2001. Mr. Sanders has more than 20 years of experience as a public interest lawyer in Eastern Kentucky. Mr. Sanders has represented miners in whistleblower discrimination cases as well as black lung benefits cases. Welcome. Ed Elliott is Director of Safety and Health at the Rogers Group and is testifying on behalf of the National Stone, Sand, and Gravel Association. Mr. Elliott has been with Rogers Group in various safety positions since 1985. Mr. Elliott has earned numerous awards, including the National Stone, Sand, and Gravel Association Safety and Health Professional of the Year for 2002, the Aggregate Managers Magazine Ag Man of the Year for 2004, and Kentucky Crushed Stone Association Miner of the Year for 2014. Welcome. Michael Wright is Director of Health, Safety, and Environment at the United Steelworkers. As a former United Steelworker member myself, welcome. Mr. Wright has been with the Steelworkers since 1984. He served as a representative to the Bhopal accident investigation. Mr. Wright is often the Steelworkers representative at regulatory and congressional hearings. Welcome. Bruce Watzman is the Senior Vice President for Regulatory Affairs at the National Mining Association. Mr. Watzman has worked for the National Mining Association and its predecessor, the National Coal Association, since 1980. Mr. Watzman was recently appointed as a member of the Mine Safety and Health Research Advisory Committee, and I welcome you. I will now ask our witnesses to stand, as is our requirement here, and raise your right hand. Do you solemnly swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth? Thank you. You may be seated. Let the record reflect our witnesses each answered in the affirmative, and you may take your seat. Before I recognize you to provide your testimony, let me briefly remind you of our lighting system, and I think most of you understand that. It's traffic light. As long as it's green, keep going in your 5 minutes of testimony. When it hits yellow, rush through or slow down, but to the point when it turns red, end your comments as soon as possible to give us an opportunity to ask the questions, probably to respond to what you wanted to say anyway. And so now, for the first 5 minutes of testimony, I'll recognize Mr. Jeffrey Kohler.
Good morning, Mr. Chairman and other distinguished members of the committee. My name is Jeff Kohler, and I am a professor and chair of mining engineering at Penn State. I am pleased to be here today to provide a forward-looking perspective on mine safety based on my experience of more than 40 years in mining, working in academia, government, and industry. The global economy continues to be powered by mining and mine products. Examples include energy sources like coal, construction materials that utilize iron, copper, or aggregates, the rare earth minerals, pharmaceuticals, agricultural produce, and thousands of everyday items that depend on mining. The associated mining and processing operations are a significant driver for the economies of the producer countries. 15% of the U.S. and 25% of the global economy, for example. Fundamental economic value and wealth are created in the transformation of materials from the Earth's crust, and the welfare of the men and women who make this possible must be of the highest concern. Remarkable gains in mine safety have been made over the years, but more remains to be done. The goal must be to eliminate fatalities and further reduce injuries. Indeed, many mining companies have committed to the goal of zero harm and are to be commended for taking actions to achieve it. If we are to be successful on this journey to zero harm across all commodities and at all mines, what steps should be taken? We need to dispel the belief that compliance with regulations is sufficient to prevent adverse safety outcomes. Regulations provide an important base to define minimum performance, but regulatory intervention alone won't do it. Engineering interventions, such as new technologies and design practices, will contribute to improved safety, but alone will not take us to the goal. Training, the third intervention of a triad that has characterized the long-standing approach to improving mine safety, also will contribute to incremental gains. But as with the other two intervention approaches, it has limitations. Instead, we should recognize that safety performance is the result of a complex system of organizational, managerial, labor, and technical components, and we must manage it accordingly and involve people from every part of the mining enterprise. A framework for this is commonly known as a health and safety management system, and such systems have been put into practice in other industries and countries. The National Mining Association, for example, has led the development of a comprehensive system for mining known as Core Safety and has developed materials to expedite implementation. Already, companies in the coal, metal, non-metal, and aggregate sectors have embraced Core Safety and its principles. The journey to zero harm with this approach at its core will not happen overnight, and it will not be without its challenges. However, in my view, this approach represents a game changer that will enable a change in the safety culture and facilitate attainment of the goal, much as has happened elsewhere. The in-place regulatory interventions will remain important, as will enforcement of those regulations by a well-trained and equipped inspectorate. Training interventions for everyone involved in mining will be as important as ever, but to be effective, we must bring our training practices and requirements into the 21st century. As a start, the findings of a recent National Academy study on improving self-escape for mine workers offers important insights to improve the effectiveness of training in general. The Miner Act brought new technologies into the mines, such as the communications and tracking systems in use throughout the coal industry, as well as the long-awaited improvements in oxygen supply. The principles of human systems integration will allow future engineering interventions to be even more successful. Occasionally, despite the best efforts of manufacturers, government, and industry, a technology falls short. Such is the case with mobile refuse chambers. Miners and mine operators have no confidence that these units can be deployed and utilized to save lives during an emergency. Rather than continue a facade, we should move forward with a known and workable alternative, the in-place shelter. While not perfect nor universally applicable, it represents a superior alternative for a majority of miners. Finally, I'd like to underscore once more the importance of mining to this nation and the importance of mine workers' safety to mining. Also, I would note that research and the research products from the great mining schools in this country will help this vital industry to remain competitive and to achieve its goal of zero harm. Thank you.
Thank you. Now recognize for 5 minutes of testimony, Mr. Sanders.
Thank you, Chairman Walberg, Ranking Member Wilson, and the other members of the subcommittee. And I appreciate your commitment to protect the health and safety of America's miners. My name is Steve Sanders. I'm an attorney, and I have been representing miners and widows in black lung benefits claims for over 25 years. I've also represented miners who were victims of discrimination for insisting on safe working conditions. There are 3 points that I want to make today. First, black lung is a serious problem, and it continues to disable miners and cause death. New data shows that the most serious form of coal workers' pneumoconiosis is present at an alarming rate. MSHA's regulations reducing respirable dust levels and requiring continuous personal dust monitors and other measures to get accurate sampling of dust exposure are critical for protecting miners. Additional safety measures encouraging miners to use their statutory rights as miners' representatives and to be protected from discrimination are needed. And third, the Black Lung Benefits Program is a good program. It serves people well, but there are improvements needed to make it a fairer and more efficient program. The continuous personal dust monitor is long overdue, and it is necessary to fulfill the promise made nearly 50 years ago in the 1969 Mine Safety Act, which said that the purpose of the law is to provide that working conditions in mines are sufficiently free of respirable coal mine dust to permit a miner to work during his entire working life without any disability from pneumoconiosis or occupation-related disease. Coal workers' pneumoconiosis is preventable. It's caused by breathing minute dust particles, small invisible particles that get into the lung and destroy the lung tissue and cause fibrotic reactions. Some individuals develop a more complicated form of pneumoconiosis, sometimes known as progressive massive fibrosis. Recent reports from NIOSH show that in the last 15 years, there has been an alarming rise in the incidence of progressive massive fibrosis, and that the disease is at the highest level since the early 1970s. The continuous personal dust monitor will allow miners to monitor their own exposure to dust. This is the continuous personal dust monitor, if anyone wants to look at it. It is designed so that it picks up the air where the miner is working, and it can show on a monitor what the exposure is. Using that information, miners and management can prevent exposure to excess dust. I also support MSHA's new requirements that dust sampling be done at no less than 80% of average production, and that sampling be done for the full working shift, not just for 8 hours. As this dust monitor becomes a tool for miners to use to detect high levels of dust, it is important that miners use their statutory safety rights. It is important that MSHA strengthen the role of what is known as a miner's representative, and that MSHA assist minors who feel that they've been retaliated against for making safety complaints. In my testimony, written testimony, I discussed the cases of Scott Howard and Reuben Shimwell, and they illustrate how some coal companies try to discourage minors from making safety complaints and how they retaliate against minors who do make complaints. As the judge noted in Mr. Shimwell's case, where the company sued him in state court after he had filed a protected mine safety complaint, the primary effect of the civil suit was to discourage future complaints from other miners. The coal communities often are small populations, and that word goes out that somebody has been, if you will, that the company has responded in a heavy-handed manner. I also wanted to make a few comments about Black Lung Benefits Program. It provides much-needed financial support for disabled miners and widows, and it provides the miner with medical treatment for his respiratory condition. But there are areas that it needs to be improved. The facts in the Gary Fox case showed that some companies cherry-pick their evidence that they show to the pulmonary experts that they submit to judges to support their defense of the claim. No family should have to endure what the Fox family had suffered. Any medical information that the coal company acquires concerning the miner's condition should be disclosed. The other, I say I'm running out of time, but if I could just mention, thank you. The other part of the bill that I think is very important is there's a provision in there to assist miners in getting attorneys to represent them in these claims because they are complex claims, and to assist miners in obtaining sophisticated medical evidence to support their claims. And finally, there is a necessary delays in processing these claims, and if the committee could assist in seeing that that backlog of claims pending at the Office of Administrative Law Judges was able to be processed in a more speedy way, it would be a great service to miners and their widows. Thank you.
Thank you, Mr. Sanders. Mr. Elliott, I recognize you for your 5 minutes testimony. Thank you.
Thank you, Chairman Wahlberg, Ranking Member Wilson, and members of the Subcommittee on Workforce Protections. My name is Ed Elliott. I am the Director of Safety and Health for Rogers Group Incorporated. Today, I'm pleased to testify on behalf of the National Stone, Sand, and Gravel Association. Rogers Group is the largest privately owned crushed stone producer in the nation, providing construction-grade aggregates, transportation and infrastructure construction services in 11 states. The shareholders and leadership of Rogers Group Incorporated are committed to the safety and well-being of their employees, neighbors, and communities. The National Stone, Sand, and Gravel Association is the world's largest mining association by product volume. NSSGA represents the crushed stone, sand, and gravel industries, and its member companies produce more than 90% of crushed stone and 70% of the sand and gravel consumed annually in the United States. The aggregate sector has a long history of commitment to becoming the safest and healthiest possible in the production of aggregates. We collaborate with government agencies, most notably MSHA, with which NSSGA signed an alliance agreement for education and training 13 years ago. This has given birth to a number of effective compliance assistance programs, such as safety alerts derived from MSHA injury data. Also, we collaborated with MSHA on the development of an instructional video for MSHA inspector trainees on the operator perspective on compliance. Nevertheless, we find many of MSHA's regulations overly burdensome without requisite benefits to health and safety. We believe the proposed civil penalties reform rule does not meet its stated goals and is likely to result in dramatic increases in penalty assessments. Additionally, we are concerned that MSHA's regulatory agenda calls for a rule on crystalline silica to be proposed next April. We believe that an objective rendering of the relevant scientific evidence demonstrates that the current permissible exposure limit, if fully complied with and enforced, is protective of worker health. MSHA is to be applauded for its good stakeholder outreach, which has been ramped up in the past several years. Also, the agency has achieved important reductions in inconsistent enforcement by its inspectors. but improvements are still needed with ongoing vigilance by agency leadership. Regrettably, however, we believe that MSHA enforcement efforts have not focused as much as they should on those conditions of highest risk, especially in today's resource-challenged environment. We believe that MSHA enforcement should focus on areas of greatest potential peril. The dichotomy of more expansive enforcement, simultaneous to operator success in continuing to reduce injuries and fatalities, risk undercutting the cause for safety and health. It also jeopardizes the perception of MSHA as a genuine, respected government entity working for the common good. Many operators fear there is a bureaucratic push within the agency for inspectors to meet a quota of citations written. While agency leaders deny any quotas, it is difficult for operators to conclude anything else based on experience. One excellent operator last year saw around half of all routine inspections result in 0 citations. This makes sense because the operator has been diligent in investing time and capital into clearly meeting all MSHA standards. However, what does not make sense, in 2015, inspectors have issued a significant increase in the number of citations simultaneous to the company having further improved its safety performance. Inspectors arrive saying in advance, "This will not be a 0 citation inspection." I hope you understand operators cannot help but wonder if a decision is based on the facts or on bureaucracy-based pressure within the agency to boost the number of citations issued. We believe that improvement would be achieved if MSHA would establish a pattern of compliance program. This would enable the inspectorate to grant some form of enforcement credit to operators for outstanding adherence to MSHA standards and keeping low rates of injuries. We support further investment in compliance assistance as called for in the Mine Act. Quality training materials that demonstrate compliant practices should become an agency point of emphasis. Also, we support revitalization of the agency's provision of quality compliance assistance to small mine operators. Mr. Chairman, we stand ready to work with MSHA in a common sense approach to regulation and enforcement. Further, we urge that MSHA seek new and innovative ways to help us achieve our common goal of 0 injuries in a way that the limited resources of the federal government can be targeted at the most serious hazards. Thank you, and I will be happy to respond to any questions.
Thank you. Mr. Wright, recognize you now for your 5 minutes of testimony. Welcome.
Thank you, Mr. Chairman, and thank you, Ranking Member Wilson and other distinguished members of the subcommittee. My name is Mike Wright. I'm the Director of Health, Safety, and Environment for the United Steelworkers. Our union represents 850,000 workers in a wide variety of industries, including the majority of unionized metal and non-metal miners in the United States and Canada. Altogether, we represent more than 15,000 miners who work in about 138 mines in the U.S. We represent another 18,000 in Canada. I've never worked as a miner personally, don't consider myself to be one, but I've done safety and health work in several dozen mines in the United States, Canada, Poland, and Russia. I'm also a member of NIOSH's Mine Safety and Health Research Advisory Committee, and for what it's worth, my Part 48 training is up to date. MSHA's impact has been enormous. Even if we take into account the decline in mining employment since 1977, the year the Mine Act was passed, the death rate from traumatic injury in our nation's mines has dropped by 77%. And that number doesn't include the miners saved from lingering deaths from diseases like black lung and silicosis. Of course, MSHA was not the sole cause of the decline. Technological change, mine safety research, mine operators themselves, mining unions all played a part. But MSHA was the driving force, the catalyst for all the good things that happened. Even so, there's lots of room for improvement. We lost 45 miners in mine accidents last year, 25 so far this year. Let me offer a few suggestions for improving mine safety and health. Most importantly, there should be no backward steps. Every year there are proposals to exempt a particular group of mines from some set of legal requirements, or to cut back on inspections and penalties, or to shift MSHA's resources away from enforcement toward voluntary programs, or to reward so-called safe mines. The problem is determining that a mine is truly safe and stays that way. Our union has some sad experience with this issue. On April 9th, 1992, the West Ray coal mine in Nova Scotia won the prestigious John T. Ryan Award, given annually to the Canadian coal mine with the fewest injuries. Exactly 1 month later, a methane and coal dust explosion killed all 26 miners underground at the time. We were working at the time to bring the mine into our union, and although it never reopened, we continued to represent the families and the remaining miners through the long years of inquests and hearings, and that is the worst mining disaster in recent Canadian history. Other proposals would disallow MSHA citations for first violations, giving those mine operators a free pass to violate the law until caught. Miners, of course, get no such free pass and do not spring magically back to life the first time they are killed, like in some video game. Others would give more weight to voluntary compliance. We are all for voluntary compliance, but the problem with voluntary compliance is that not everybody volunteers. In fact, enforcement stimulates voluntary efforts. Reduce the one and you will reduce the other. What about forward steps? Let me suggest a few. First, MSHA enforcement is based on a rule book of mandatory standards. Those standards are necessary, but no effective corporate safety program relies on passive compliance with a rule book. Instead, good programs actively seek out and correct workplace hazards. MSHA began preliminary work on a new safety and health program standard 6 years ago, but it's languished. No new regulation or initiative would have a greater positive impact on mine safety and health. Second, MSHA should take a careful look at the effectiveness of its current Part 46 and Part 48 training programs. Problem's not so much the length of the training, but the content and especially the methodology. Too often, miner training, especially refresher training, consists of bored miners watching PowerPoints or videos from equally bored instructors without any real interaction or discussion of the safety problems they encounter on the job. A full-scale review by MSHA, including experts in in adult education, could lead to new guidance, regulation if necessary, and in the end, to better trade miners. Third, there should be greater collaboration between OSHA and MSHA. There are some hazards that overlap between the two agencies, and we've seen too many examples where OSHA and MSHA go their separate ways and don't work together. That should change. Finally, let me turn to what Congress could do. The Mine Act is a good law, but it has a few key flaws which could be corrected. For example, MSHA should be given subpoena authority. That is enjoyed by OSHA and by other federal agencies. MSHA needs that to conduct investigations. Second, there should be a better way to collect uncollected fines. We think that could be done through withdrawal orders, but MSHA would need legislative authority to do that. And finally, criminal penalties need to be increased. It's scandalous that the penalty for killing a miner through a willful violation of a standard is 1 year in prison. To give a counterexample, the penalty for damaging a coral reef or for harassing a wild burro on federal land is 5 years. What message does it send when the federal government values the serenity of a burro over the life of a miner? These problems and others could be corrected by H.R. 1926, the Robert C. Byrd Mine Safety Protection Act of 2015, introduced by Representative Scott, the ranking member of the full committee, and co-sponsored by Ranking Member Wilson and many others. We urge its passage. Thank you.
Thank you. Now I recognize for 5 minutes of testimony, Mr. Watsman.
Thank you, Mr. Chairman, Ranking Member Wilson, and members of the subcommittee. I appreciate the opportunity to be here. In the time I have, I want to cover 2 areas: what we're doing voluntarily to drive safety performance improvement, and problems with MSHA that are impediments to improvement. In 2011, after having concluded that the current pace of safety performance was not acceptable, NMA initiated Core Safety, a first-of-its-kind safety and health management system designed specifically for U.S. mining to take a more aggressive approach to improve performance. At the heart of Core Safety is fatality prevention and risk management. Core Safety is not about saving miners after accidents. It's about identifying at-risk conditions, practices, and behaviors that lead to accidents in order to prevent them, and it's making a difference. In our view, risk-based safety and health management systems are more likely to move safety performance to the next level. Experience shows that safe behavior does not occur in a vacuum. It's shaped by leadership and culture. These are characteristics that are taught and nurtured, not legislated or regulated, and they're at the heart of Core Safety. Beyond what the industry is doing voluntarily, we're long past the time of debating the need to reform MSHA. to modernize the agency and the manner in which it conducts its business. Despite what some believe, impact inspections, rules to live by, and a pattern of violations will not get us to zero fatalities. MSHA enforcement initiatives, by focusing on conditions, represents a reactive approach to safety that has had and will continue to have limited access. We have an opportunity to drive further improvement, but not in the enforcement environment that exists today. Today, the mining industry is undergoing fundamental change, but the agency is wedded to a model with diminishing returns. From 2010 through the end of 2014, the number of operating mines has declined precipitously. Yet during this period, MSHA's budget, including the request for this year, is a 12% increase. The reduced number of mines provides an opportunity to reevaluate how MSHA allocates its resources and how the resources are applied. MSHA remains affixed to a model where today it is not uncommon for multiple inspectors to be on site every day. This is unnecessary and counterproductive, and as one might expect, enforcement leads to adjudication, and this is the second area in need of a reform, the broken citation conference process. Another area in need of reform is MSHA's selective recognition of the incorporation of new technology. The Miner Act established within NIOSH the Office of Mine Safety and Health. The office is responsible for research, development, and testing of new technologies and equipment designed to enhance mine safety and health. While MSHA is not bound by NIOSH's recommendations, they in some respects have become the technical advisor to NIOSH. In this regard, we're concerned that MSHA, in certain instances, prematurely promulgates regulations that impose technology requirements in advance of NIOSH completing the necessary research. An example will illustrate this. On September 15th of this year, MSHA issued a proposed rule to require operators of underground coal mines to equip certain pieces of equipment with what's known as proximity detection technology. While proven on an earlier category of equipment, this technology suffers from interference problems on the category of equipment covered by this proposed rule. Despite this, and despite the fact that NIOSH has not tested the technology, MSHA's proposed a rule that requires the wholesale application of this, where practically every application is unique and most are still untested. Furthermore, the structure of the rule creates a huge disincentive for operators to apply the technology ahead of the rule. Similarly, we continue to face problems relative to the new technology required by MSHA's final coal dust rule. The inability to differentiate between rock dust and coal dust particles gives rise to a conflict between the coal dust rule and the agency's enhanced rock dust requirements. Additionally, the difference in sample compliance determinations using the current sampler and the new sampler continues to raise concerns, especially as the February 2016 date for the phase-in of the second part of the rule looms. Finally, it's time for MSHA to adopt a voluntary protection program for mining. Some will take this to mean that we're advocating an end to what's commonly referred to as the 4s and 2s, the statutory requirement for inspection at all mines. Let me be clear, that's not what we're advocating. Rather, a VPP would provide MSHA the ability to shift its focus at exemplary mines, which it would determine, from an enforcement to a compliance assistance approach. In closing, let me stress that to modernize and improve safety performance, we need to move beyond a model based strictly on enforcement. Enforcement is necessary, but we have to develop higher standards that engage employees and encourage cooperation. Core safety and the VPP program are positive steps that would move the industry in that direction. Thank you.
Thank you. And as I listened to each of you, it's interesting to think about the impact of mining. I jumped on a Great Lakes freighter at the Port of Monroe in my district this past Sunday night, watching the unloading of tons of coal into the hopper from a Great Lakes 1,000-foot cargo ship headed up through Detroit River, Lake St. Clair River, Lake Huron, St. Mary's River to the Sioux Locks, and all along the way I saw either piles of aggregates, metallic, non-metallic piles for steel mills and power plants all along the way, all a result of mining industry. And each of you represent portions of that we want to make sure works. So thank you for your testimony. Let me welcome also to our committee a distinguished colleague from Pennsylvania, Congressman Cartwright. Thank you for joining us. Without objection, Congressman Cartwright is permitted to participate in our hearing today, and I certainly hear no objection. It's also a delight to welcome a good friend and colleague, Mr. Courtney, to join us today as well. I recognize myself now for 5 minutes of questioning. Mr. Watsman, on September 26th, the committee requested MSHA provide information related to the mandatory operation of continuous personal dust monitors. We have evidence of one here in the room. In light of potential for new rock dust composition to prevent CPDM from accurately reading coal dust in the atmosphere. Just Monday of this week, we received a letter back from MSHA, and I'll place that letter into the record without objection, hearing none. MSHA states that the concerns expressed in the letter are unfounded. Mr. Watsman, I know that you received a similar letter this week. Do you agree with MSHA's assessment of CPDM as it relates to changes to rock dust?
We don't agree with the agency. We similarly have reached out to the agency to try to work cooperatively with them. We've sought their participation in undertaking studies underground, looking at rock dust and coal dust and the possible contamination of one by the other. And up to this point, the agency has not been willing to participate in a robust, peer-reviewed study with all of the stakeholders. So we think it's a problem. We think it's something that needs to be studied, and hopefully that will occur before the February implementation date of the second phase of the rule where the CPTM is required.
What might be the reason for a problem in participating in that study?
That's left to best to be answered by MSHA. We don't know why. I mean, we're all seeking the same goal here and the same objective, and that's to protect miners and to do it in an accurate manner. We don't know why MSHA has been resistant and not willing to participate with us.
Mr. Elliott, MSHA is a unique agency in that it is required to inspect all facilities under regulatory arm at least biannually. NSSGA members, your members, will see an MSHA inspector at least twice a year, if not 4 times, if I'm correct. As a safety and health professional, what do you think would improve the interaction between mine operators and MSHA?
That's a good question. When you look at the circumstances in many instances where an inspector comes on site, they are looking primarily focused on regulations and what violations they might be able to find. I think by opening up a broader dialogue, as Mr. Wright talked about, looking at the overall safety and health program at a mine, that inspector could get a better idea of what's going on in the process of managing safety every day. To your point about the inspector may come 1, 2 days, 3 days, maybe even 4 days at a large mine, but the rest of the year, they're not there. And they can't regulate how those miners are going to act or the operator's going to act once they're not there. So I think just opening up a broader dialogue about safety as a whole versus just regulatory enforcement would be of great benefit coming from both sides.
A true partnership.
Yes, sir.
Dr. Kohler, you have extensive experience in this field, especially in the area of safety. You've been following the CPDM rock dust debate, I'm certain. Can you provide additional insight about the concerns each party is expressing?
Yes, I can. You know, first, you know, the use of real-time monitoring devices represents a great opportunity to deal with a lot of occupational health problems that we couldn't deal with before. So the advent of a technology like PDM, we viewed, 10 years ago, 5 years ago, as being the single greatest opportunity to eliminate black lung, because for the first time, people would know in real time what the exposure was, and they would be able to address that exposure. More recently, that vision that I and others shared to do that has developed a problem, and that is a conflict with the rock dusting practice. A few years back in NIOSH's investigations, they determined that the amount of rock dust being used was not protective and the amount needed to be increased. Further, they determined that the existing standard for rock dust, the definition of rock dust, also was in need of modification to make it more protective. So the end result of this is that there's been a tremendous increase in the amount of rock dusting, and also rock dusting more extensively throughout the mine. A few years back, we looked at rock dust as a nuisance, and we never really thought a lot about the impact of rock dust on something like a respirable dust sampling program. It turns out that rock dust is a confounder. Rock dust shows up on the cassette in this PDM the same as coal dust does, and it effectively wipes out the ability to know what the coal dust exposure is, which is the bad actor that we're trying to deal with. So there are important reasons why this needs to be resolved, and it's essential that we resolve it through additional testing, experimentation, and we make an experiment-informed decision about how to go forward with this important technology.
Thank you. My time has expired. I now recognize the ranking member, Ms. Wilson, for your 5 minutes.
Yield to Mr. Ranking Scott. Member.
I yield to Mr. Scott, and if I'd see the program here, I would have known that. Mr. Scott.
Thank you, Mr. Chairman, and I appreciate the ranking members asking me to be recognized first. Mr. Sanders, the device beside you does real-time monitoring. How is that different from what's going on now, and why is that important?
It's important, Mr. Scott, the real-time monitoring enables the miner and the mine management to know what the level of respirable dust is that the miner in the atmosphere where the miner's working. I'm not an expert on these devices, but this clips to the miner's clothing, and it actually takes in a sample of air.
How is that different from what's going on now?
What's going on now, the miner is generally not being able to get the real-time readout. That is, the information is collected, but then it's later processed, and the information comes back days or even weeks later. And by that time, the atmosphere is continually changing. They're moving forward or retreating in the mine. But the information that comes back may indicate that there was a violation, but it doesn't really help us to correct the problem to prevent the injury.
Thank you. Now, Mr. Sanders, the Black Lung Benefits Program is an adversarial system. In your testimony, you talk about the fact that workers are not well represented. What specific proposals would you have to level the playing field so that workers could be better represented in this adversarial proceeding?
I think that the legislation that's been proposed, the Black Lung Benefits Improvement Act, has a very good basis. What I think are the problems are partly that attorneys are deterred by the complexity, the need to develop sophisticated medical evidence with a client who has no resources to pay for that development, and the attorney cannot be paid for his services by his client. Under the federal Black Lung program, it's the attorney that represents the claimant gets a fee if the claimant is awarded benefits and if the award is upheld through all appeals so that the award is final. Well, in many of these cases, I would say the average is at least 4 years before you get to that point. And in many of the cases, they go on longer. There was an article recently in the Charleston Gazette about a case that went on for 21 years. The attorney representing the miner in that claim gets no compensation unless the miner wins and the award's upheld. So the Black Lung Benefits Improvement Act created a way that an attorney could get a partial fee through the trust fund if they're successful at various stages in the proceedings, and then that payment from the Black Lung Disability Trust Fund would eventually be paid back by the operator if the award is upheld. It also provides for a payment for medical expenses incurred by the claimant to develop the kind of sophisticated evidence that they need to prove their case.
Well, speaking of medical evidence, the Department of Labor has decided not to accept medical evidence from a particular physician whose diagnosis turns out to be somewhat questionable. If someone has been disadvantaged by bogus medical evidence, what can be done? What should be done for those cases?
In the particular case you're talking about, the Department of Labor determined that a particular radiologist's readings where he never read an X-ray to show complicated pneumoconiosis or progressive massive fibrosis, despite many cases where minors died and their autopsies proved they had that condition. They said that any claimant whose claim turned on that doctor's reports would get another shot at it. I think that was a good result. I think so much of this, though, is really a battle of medical experts, so it's hard to know at what point does the expert simply become a fraud, and that's hard to remedy that other than good representation in the individual claim.
Thank you. Thank you. Mr. Wright, you indicated the importance that safety inspectors have subpoena power. Why is that important?
Well, because in doing especially a complicated investigation like Upper Big Branch, they need to be able to compel testimony, and they need to be able to compel the production of documents which may not be documents that are normally required under the Mine Act, but which are nevertheless relevant. In the Upper Big Branch investigation in particular, since MSHA did not have subpoena authority, it had to work through the state agencies and really do its investigation through the state, which did have that subpoena power. That worked in West Virginia. Wouldn't work in Nevada, wouldn't work in Wyoming, where there is no such state power. So it makes a lot of sense to us that since OSHA has that kind of authority, since many other federal agencies have that kind of authority, I think the example I used in my written testimony was the federal agency charged with promoting the use of popcorn actually has subpoena authority. MSHA does not, and that should be corrected.
Thank you, gentlemen. I recognize now the gentleman from Indiana, Mr. Akita.
Thank you, Chairman. I appreciate you organizing this hearing. I appreciate everyone's testimony this morning. Mr. Sanders, are you familiar with the concept of the Voluntary Protection Program as used in other agencies, not MSHA, but in other agencies?
No, I'm not.
Thank you. Mr. Wright, are you familiar with the concept of a Voluntary Protection Program as used in other agencies?
Yes, very familiar.
Okay. Do you have positive things to say about such a program?
I have positive and negative things. I think
Tell us the positive.
What's the positive? Okay. I think a lot of companies want to be in the voluntary protection program in part because, and this is OSHA now, in part because it frees them from routine OSHA inspections, but it also is a kind of a badge of honor.
Creates good competition and has a higher level, and I appreciate that.
One of the things we like about it is that a company that is unionized cannot be in the VPP unless the union agrees.
Right.
So there's a pretty good check on that.
Thank you, Mr. Wright. For the benefit of Mr. Sanders, I'd like Mr. Watson to go into some detail about the Voluntary Protection Program. You see, I got a bill that several of us in Congress are on that's trying to codify that as an eligible use across agencies, including MSHA, and I'd like to know in particular more detail on how you think MSHA and therefore minors would benefit from using a VPP.
Thank you for the question. We think it will work for MSHA. We think the experience in OSHA shows that it's transferable to MSHA, and that MSHA can structure the program, put in the proper safeguards, so that if a mine falls off the wall, as Mike talks about, and doesn't maintain a certain level of performance, that they can be removed from the program. Most importantly, we think that it will give MSHA the ability to refocus how it allocates its resources and conducts its work. Right now, the inspection regime is very rigid. The Mine Act uses the phrase "in its entirety," and MSHA interprets "in its entirety" in the broadest sense possible. There are areas of mines where hazards present themselves. There are other areas of mines where those hazards don't exist. There are mines in this country that have existed for 30 or 40 years or more, where you travel down entries where rocks don't move. They haven't moved in 30 years, yet MSHA commits the same resources inspecting that portion of the mine that they do where the hazards present themselves. So that's what we think that would afford the agency
And in
to
fact,
do.
the VPP companies that I've seen in different industries, to get to that standard, to be let go from some of the routine inspections that Mr. Wright kind of describes, you have to get to even a higher level of compliance than you would to normally. Is that correct?
That's exactly right.
All right, thank you. Mr. Elliott, you talk about a pattern of compliance program. Is this the same as VPP, or is this something different or just as useful, or another tool that could be in MSHA's toolbox? What?
I think to your point, it is very similar, and it would be a situation where if the mine could demonstrate compliance, as the VPP program points to, then I think the similarities would be very close.
Anything else about a pattern of compliance program that works at the state level somewhere, or any kind of model we might study further?
Well, my experience has been in a number of states that they're more focused on coal. The crushed stone, sand, and gravel is not the coal industry. And when we look at those agencies that may come in and are supportive and helpful, I think the MSHA Small Mines Office was an example of that, where they went into the small operators and tried to help them understand compliance and tell them the ways that they could be more efficient if they were more compliant. I think those are the steps that MSHA was somewhat moving in that direction.
Okay, thank you. I yield back.
I thank the gentleman, and now reading my script here, I recognize my ranking member, Ms. Wilson.
Thank you, Chair. Mr. Saunders, I want to commend you for your 25 years of commitment to representing coal miners and their survivors attempting to obtain black lung benefits. Can you explain to us why it is often difficult for miners to find legal representation for black lung benefit cases? And why are we seeing a spike in new cases of black lung? And how do you think the new respirable dust rule will affect this trend? Because people are dying.
Yes. I think it's difficult for minors and widows to find representation because of the complexity of the claims, the bureaucratic complexity, and the medical sophistication of the medical evidence. We're talking about proving disability in a pulmonary system and the cause of disability. So those are fairly complex questions and require some, you really have to develop some knowledge about that. In addition, because the claimant cannot pay their attorney, many attorneys don't want to take this kind of work on with the expectation that they're not going to get paid until the award is final, which may be several years from now. There's other work, legal work that you can do that you can get paid up front, or you're going to get your fee soon after. And the amount of the fee is not that high. On an individual claim, it's based on your services, it's based on the amount of time you put into the case, so it's not as if you're handling a large fee contingency type case. With regards to, did you ask why are we seeing increased number of cases of black lung? You know, there's some speculation about it. My own opinion is that modern mining methods using continuous mining machines generate a great deal of really fine particulate, really fine coal dust and rock dust. In eastern Kentucky, a lot of the coal seams that they are mining now are separated by bands of silica rock. So when a continuous miner operates, it cuts into both the coal and the rock, and the miners are exposed to that in the air. I think years ago there in eastern Kentucky, a lot of the mining was done shooting the coal, and they weren't creating this fine particulate matter mixed coal and rock. So I think that's part of the problem. Another part of the problem could be that miners are working longer shifts consecutively, so there's not time for the dust to clear out of their lungs before they go back to work and are exposed again. That's another theory that is being, I think, looked at. Was there a third part of your question, Ms. Wilson? I'm sorry.
Yes, I wanted to know how the continuous personal dust monitors would help.
Well, they could help a great deal, because if you're using this and it has this digital readout area, and you can look at that and you can see what the exposure is where you're working, then you can say, I don't have good quality air. Something needs to be done. Mines use environmental controls to get good quality air into the areas where the miners are working. Could be a matter of changing the way the curtains are aligned or increasing the amount of airflow into that particular area, but it would reduce the miners' exposure to excess respirable dust immediately.
Mr. Watsman, you suggested that MSHA was not cooperating with the industry, and that you had some complaints about the continuous personal dust monitor and the possible interference caused by rock dust. Can you elaborate on that for me so I'll understand exactly what you mean?
Yes, I can, and let me state first that we were involved in the development of the CPDM. We supported the development, we support its application and use. But we have to make sure that we're not substituting one problem for another. There is little confidence in the technology that's used today, the gravimetric sampler. We need to make sure that the results from the CPDM are accurate, and that's what's lacking today. When we're sampling, rock dust becomes entrained in the air, and the dust sampler is picking up both rock dust and inert dust. And we did a search and couldn't find any health studies that indicated any adverse health outcomes related to rock dust exposure. So
Well,
the sampler is picking
What I have
up.
here is, I don't want to run out of time. We have a letter from the Assistant Secretary of Labor for Mine Safety and Health, and he says that he's working with you in collaboration with the mining industry to conduct in-mine evaluations to identify and apply best practices for managing rock dusting and dust sampling.
And we wish them well on that. And
so let's hope that it's taking place and that you have the opportunity to experience that.
It may be taking place episodically at individual mines, but I can tell you that it is not taking place with the industry as a whole. To the degree that we conducted our own sampling and provided the results to the agency and have yet to have a response from the agency in terms of meeting with us to discuss the results we presented.
the gentlelady's
According to
time has
this,
expired, and so we'll move on here.
We do have a response, and perhaps it just hasn't gotten to you.
Well, we'll look forward that all responses go to the right sources, and we take appropriate action and save miners and an industry as well. I now recognize the gentlelady from New York, Ms. Stefanik.
Thank you, Mr. Chairman. This question is for Mr. Watsman and Dr. Kohler. When I visited Nyco Minerals in my district, which is one of the few mines in the world that produces wollastonite, a mineral with wide commercial use for ceramics, brakes, clutches, and plastics, it was clear to me that we need to do more to support the workers that help to keep our nation's global competitive edge. What can be done, in your opinion, to strike that intelligent balance between protecting these workers and making sure that we do not curb further economic growth by stifling these companies with litigious regulations? And I'll start with you, Mr. Watsman.
Well, I think it goes back to what we've touched upon on so many occasions here, and that's creating a cooperative environment. where we in the agency sit down and address problems rather than going to our respective corners. Mining is a very tough business, and it's a very challenging business today. I look at the coal industry, where the number of mines since 2011 has dropped by 18%. The number of mines in this country has dropped overall in that same period by 4%. Yet MSHA is getting more resources and is refusing to change the way they conduct their business. I think we have to all honestly ask ourselves the question, is the old model working? You know, we've been under the Mine Act for 46 years, and we've made phenomenal progress as an industry, working with our workforce, working with regulators. But after 46 years of one model, shouldn't we be better than we already are? And that's really what drove us to core safety, to look outside the box, to look for a different model that isn't enforcement-oriented, but is proactive rather than reactive, identifying risks at the outset and engineering those to the degree you can out of the work environment to better protect our workers.
Dr. Kohler?
Yeah, I would say two things. First of all, I think that the sitting down and talking, the partnership is critical. And the toughest problems we've faced in mine safety and health in the past 15 years were best solved when industry, organized labor, MSHA, NIOSH, manufacturers all came together, rolled up their sleeves, and tried to solve the problem. And I think we have to have that kind of partnership. Secondly, I fully support this idea of occupational or health and safety management systems, whether we call it core safety, which the NMA has rolled out, or implementations of VPP. I understand that there are good and bad parts, there are good and bad actors. It might be appropriate for an august body like the National Academies to actually resolve that question and provide guidance on how we can implement that fully.
My next question is for Mr. Elliott. Following up on concerns for maintaining worker safety, one mine safety group in my district raised concerns that workers have become increasingly concerned with being held personally liable for accidental noncompliance. And it's my understanding, and you've shared today, that over the last few years, the number of citations given at mines has increased greatly. How do we ensure worker safety and maintain an appropriate oversight system while also reforming the current challenges with this burdensome citation policy?
That's a heck of a question. If I could do that, I'd probably be in Congress. But really, when we look at the circumstances around trying to look for people to come in this industry, it is tough today. It's hot, it's cold, it's dirty, it's muddy. All those things are involved with it. And like Mr. Watsman said about the approach of the agency from maybe many, many years ago when the Mine Act first took effect, that there was methods that were successful at that time. But I think today we're in the 21st century, and we need to get greater efficiency to reach the root issues that are affecting the mining environment. Generations change. My generation is slowly but surely leaving the industry. Younger people are coming in that are more dynamic and more concerned about their safety. So I think the agency has to look at ways to change to meet the changing demographics of mining.
Thank you very much. I yield back.
I thank the gentlelady, and now I recognize the gentleman from Wisconsin, Mr. Procan.
Great. Thank you, Mr. Chairman. Mr. Wright, I'm going to go back to a question that Mr. Rokita asked you because I think you got cut off a little bit. You mentioned there were positives and negatives to the VPP. If there's any more positives you want to mention or any of the negatives, now is your chance.
Yeah, I'd like to mention some of the negatives. The program started out, I think, very usefully, but in the last administration in particular, the metric for its success, as the administration saw it, was how many companies they could get into VPP. And so we saw company after company that really did not deserve to be there. And one of the things that sort of taught us that was that we saw a lot of fatalities happening in VPP companies. And we went back and looked at what caused the fatality, and it was really, in some cases, non-compliance with standards. In other places, it was a real failure to find and fix hazards that should have been obvious. Those companies should never have been in VPP. In addition, we think that what drives companies into VPP, what drives voluntary compliance in general, is a strong enforcement program. And so we generally supported the program, but we did not support and would not support taking resources away from enforcement and putting them into VPP. Enforcement, you know, I mean, there are just too many hazards out there, too many, we see too many violations of law. We see, even with the 4s and 2s, we still see people dying in mines from hazards that went unrecognized, from hazards that may have been recognized by the company, but they did nothing about it, and from things that may not be covered by the standards, but are nevertheless very serious problems. So enforcement is what drives voluntary compliance. We can't cut that back. VPP might be fine, but not at the expense of a strong enforcement program.
Thank you. Mr. Watsman, you looked like you wanted to respond when Mr. Sanders was talking about why we're at levels back to the early 70s of black lung. I just wanted to give you that chance. You had that look on your face.
Well, I appreciate that opportunity. You know, I've said before, there is a problem in the industry with black lung, but it's not the problem that has been characterized in the public domain. It's not the problem that's been characterized by the agency. It is a geographic problem in a small area. And you know, what I do is I go back to the NIOSH X-ray surveillance program data. NIOSH conducts an X-ray surveillance program. They take their van around the country and they examine miners who want to voluntarily participate. We want it to be mandatory, but it's still voluntary. When I look at Utah, for example, they conducted 500 examinations. They expected the rate of black lung to be 4%. The rate was 0. In Illinois, they expected it to be 4%. It was 1. In Indiana, they expected it to be 4%, and it was 1. In Maryland, they expected it to be 3, and it was 0.
Mr. Watsman, just for time reasons, I just want to make sure you, so that's the main point that.
It's not the problem that has been characterized is the point I want to make.
Okay. And I assume you'd agree then that this is not a fair characterization either. In a recent phone call released during the criminal trial of former CEO of Massey Energy, John Blankenship, he said that, this is his words, that black lung is not an issue in this industry that is worth the effort that they, meaning MSHA, puts into it. I assume you don't agree with that statement.
As I've said before, there is a problem, but it's not the problem that's been characterized.
So you don't agree with that statement?
I don't.
Okay, thank you. Mr. Wright, if I can, in just the remaining very little bit of time I have left, there's been some talk about removing stone quarries from coverage under the Mine Act, putting them under OSHA. We had a hearing recently on OSHA. They can inspect one site every 140 years if they get around everything. Could you just talk a little bit about why that might be a problem?
I'll just give you one sentence. This is actually 2 sentences. Last year we had 15 deaths. I'm sorry, this year so far we've had 15 deaths in metal and non-metal mines. 9 of them have been in stone, sand, and gravel.
Great. All right, thank you. I'll yield back.
I thank the gentleman. I recognize the gentleman from Pennsylvania, Mr. Thompson.
Thank you, Chairman. I apologize for stepping out of the committee meeting, but I was talking about coal while I was there.
Oh, good for you.
And the export of some great coal. I think that's mined in Mr. Cartwright's district that we export. So, and thanks for having this hearing. Let me move this away a little bit. It's feedback. Incredibly important hearing for me personally, as someone who, my grandfather was a coal miner, surface miner, but had black lung, diagnosed with black lung. And I will say that some of just put a plug in for advocacy when folks are trying to advocate for whatever they're pursuing from a federal perspective. Use their members of Congress as advocates as well when you're looking at programs like that. And Dr. Kohler, welcome. It's great to have someone here from home. Real proud of your leadership and the work that you do at Penn State and for mining and preparing mining engineers. So my first question is for you. And I apologize maybe if this was covered already, but what I heard from the verbal testimony and reading the written testimony, it had to do with the use of the refuge alternatives in the event that a miner cannot leave in an emergency. These alternatives supplied with food, water, and breathable air have been required since 2009. Based on NIOSH concerns, MSHA has issued a request for information related to the use of refuge chambers. Can you discuss the concerns about refuge alternatives in underground coal mines?
Yes, the specific concern with respect to the mobile alternatives is that in principle it's a great idea, but given the spatial constraints in an underground coal mine, given the requirements, the time period in which they need to remain functional, given the complexity that it takes to understand how to deploy these systems, and given a number of engineering problems that have surfaced over the last 5 or 6 years, it's clear that this technology, despite the best efforts of manufacturers, MSHA, NIOSH, and everyone else, is simply not making it. And that's a reason why miners have no confidence in it at all. We have better alternatives out there, and so we need to get on with that. While it's true that the in-place shelter, for example, won't work in every single mine, and in some cases there are distance concerns, but it would serve a majority of miners, unlike the current technology.
The mine engineering obviously is a highly technical specialty, and there's great need for mine engineers in the United States. How can the industry and government attract students to that profession?
It's the greatest deterrent to students moving into the profession is the public image that the industry has. Most people don't realize how modern mining has become, that it's in most regards environmentally sustainable, responsible from a safety and health perspective. Most people don't understand the value of mine products in the economy. They don't understand that 15% of our gross national product is tied to mining. So to the extent that the industry can do a better job of marketing itself, and as we like to say, we don't often have to convince the kids to come into mining. It's their mothers that present the real challenge.
Thank you. Mr. Watsman, over the last 10 years, the number of coal mines operating in the country obviously has been sharply reduced. We've sadly watched that occur as really the coal industry has been under attack. How many coal mine inspectors does MSHA currently employ, and what have the mine operators seen as a result of having fewer mines but the same number of inspectors? And I'd also like you to reflect on, I've spent time, I have an MSHA unit in my district. They're great people. I've gone early mornings before they go out, so it's a real early start. But some of the things I've heard in terms of some of the coal individuals in the coal mines is that many of these individuals, some of the new ones coming on, just don't have practical experience. They have a lot of great education, and any reflection on how the experience, as we have attrition and have lost people who've actually worked in mining that have gone on to become inspectors. Now we tend to have, sometimes we don't have that practical experience today.
Well, let me start with your first question. I don't know the exact number, but I believe MSHA has approximately 700, give or take a few, coal mine inspectors. And that number has remained pretty constant for the last number of years, even though the number of coal mines has dropped precipitously. So what that means is you have a greater presence of MSHA inspectors at the mines that remain operating in those districts. And let's be clear, when MSHA's on site, that involves management as well. That takes away from their normal safety activities because they accompany MSHA as they go through the mines. So there is a detrimental effect to a degree from the perspective of how companies manage safety at the operations. As I said in my testimony, it's not uncommon today in some of the mines, especially in Appalachia, to have 4, 5, 6 MSHA inspectors on site every day the mine is operating. That's a dramatic change from what we saw in the past. And you're right. I mean, as the generation has changed, inspectors who were better seasoned, and this will change over time as this generation learns more about what they're doing. But we're seeing things that weren't cited in the past, are being interpreted differently by this generation as they come out of the academy, because what they've learned is they've learned the book. And that's what they follow. They follow 30 CFR. That is their gospel, if you will. So, you know, we've seen that dynamic change. Hopefully, you know, with time, as these individuals become more experienced, we'll see the pendulum swing more back towards the middle.
Thank the gentleman. Gentleman's time has expired. Now recognize, staying with Pennsylvania, the gentleman from Pennsylvania, Mr. Cartwright.
Thank you, Mr. Chairman, and I thank you for having me here in the subcommittee. I also want to recognize Mr. Thompson. Thank you for having me as well. Thank you also for sharing that about, it was your grandfather that had black lung? I have an awful lot of black lung sufferers and recipients in my district, you know, we can argue about the prevalence level, you know, the amount of black lung that's out there, but nobody would disagree that we want to make the process fair. And thank you for nodding in agreement, Mr. Watsman. I appreciate that. I'm moving this microphone as far away as I can.
It may be black lung in the system. I'm not sure.
Mr. Sanders, a Pulitzer Prize-winning investigation by the Center for Public Integrity found that doctors at Johns Hopkins Medical who were hired to help coal companies fight black lung disease. Try that.
I wish we were more accommodating to a member who joins this committee. My apologies.
Thank you.
And we're not taking your time away for that.
I appreciate that, Mr. Chairman. This Pulitzer Prize-winning study found that doctors at Johns Hopkins in Baltimore who were hired to help coal companies fight against black lung claims has systematically misdiagnosed minors with black lung as having other non-compensable diseases, thus preventing those minors from accessing benefits. It's not a funny situation. The report found that more than 1,500 black lung claims since the year 2000 were handled. Okay.
If you'd like to join us up at the upper dais here, maybe. We haven't had that problem, so let's try that. I know it can be irritating when you have that going in your own ear, so. This makes us wish for our new committee chambers, right?
My first day, and I get to be on the upper dais. Pretty good.
This is a great subcommittee.
Thank you, Mr. Chair. So we're talking about Johns Hopkins and how they had a doctor who misdiagnosed black lung disease. His name was Dr. Paul Wheeler, and the investigation revealed that in more than 1,500 black lung claims since the year 2000, Wheeler had never once in more than 3,400 x-ray readings interpreted an x-ray as positive for complicated black lung, a condition that would presumptively entitle somebody to black lung benefits. But many other doctors and autopsy results revealed the presence of the disease. Now, in response to this Pulitzer Prize-winning investigation, Johns Hopkins suspended the program, to their credit. My question to you is, what should be done to remedy this situation for minors or their survivors, Mr. Sanders?
I think that the minors or survivors whose claims contained evidence from Dr. Wheeler or the other radiologists at Johns Hopkins should be reviewed. That is, that they should have an opportunity to have their case re-adjudicated without the questionable evidence.
Okay. And now, even more troubling to me, Dr. Wheeler was certified by NIOSH to classify lung x-ray readings. He had to pass a rigorous test to become a so-called B reader, and you're familiar with that term.
Yes.
And he had to be retested every 4 years, and he apparently read the x-rays correctly on the NIOSH test, but he chose to underread X-rays in litigation. What should be done about that?
You know, that's a very difficult question, because NIOSH has operated the B-Reader program as a way of classifying X-rays under what's called the ILO system for pneumoconiosis for some time. And it's supposed to provide us with a good quality reading. It's not just for evidence purposes and black lung benefits claims, but it's actually useful for epidemiological studies. I think that there needs to be some kind of a quality assurance program, and that NIOSH has to be able to investigate questionable B-reading practices. Okay. And suspend or terminate the person's B-reader status as a result of their investigation. They have to have that authority.
That makes sense. Now, Mr. Sanders, this investigative series also revealed something that was even maybe more disappointing. It showed that coal company lawyers withheld medical evidence from claimants and their counsel where evidence proved that the miners had black lung. My question for you, is it true that coal companies have fought claims by cherry-picking medical reports that support their defensive claims and withholding medical reports that would corroborate the presence of compensable black lung disease?
That is true. And in the written materials, I discussed the case of Gary Fox. And if you look at it's a reported decision from the Court of Appeals, and if you look at the facts of that case, it corroborates it absolutely. Not only did they withhold evidence from the adjudicator, but they cherry-picked the evidence that they sent to pulmonary specialists. Then when they got the report from the pulmonary specialist, they submitted that as evidence. So they really had skewered the record in Mr. Fox's case. And it's happened in other cases. Hopefully it's not very common.
Mr. Sanders, the GAO, the Government Accountability Office, has reported that many black lung claimants are without the necessary medical and legal resources to secure benefits, and you've discussed that here today. Given the adversarial nature of black lung proceedings, DOL says only 30% of miners have legal representation where they file a claim. The coal companies always have lawyers, don't they?
Yes, they do.
Why are so few miners represented by counsel? Are there obstacles beyond the ones you've already discussed to securing legal representation?
You know, yeah, there's a limited number of attorneys, frankly, that are willing to take these kinds of cases on. I'm pretty familiar with most of the ones that are in the region of the country that I live in, and there are just not very many of us.
All right, let me ask you this. I'm the author last month of the Black Lung Benefits Improvement Act of 2015. I'm proud to say I have original co-sponsors, Ranking Member Wilson and Representative Scott on the bill. Are you familiar with that bill?
I am.
Do you believe it remedies many of the situations you and I have been discussing here today?
I do. Earlier we talked about, particularly with regards to the representation, the opportunity for an attorney, if they're representing a claimant, to get compensation for their time during the course of the adjudication. I think that would be very helpful. I think also the opportunity to get reimbursement for medical expenses so that you could better develop the evidence to prove that the claimant is entitled to black lung benefits. I think those are very important provisions.
Well, I
thank
Mr. Sanders, and thank you, Mr. Chairman. I'm sorry I broke your PA system. Yield back.
We'll find an attorney. Thank you for participating, and thank you to the panel. Appreciate the work all of you do for the industry, for individuals, for the economy, and all that goes with it. Now we have time for closing, and I recognize the ranking member, Ms. Wilson, for her closing comments.
First of all, I'd like to thank the witnesses for being here today. And I'd like to thank our chairman, Wahlberg, for holding this hearing. And I appreciate the conversation from the members of the committee. And this is very emotional for me. I just can't even imagine. In fact, I am planning a trip to a mine because I want to see. I'm from Miami, Florida, so I've never experienced this, but in the recent news, we've heard some questions about whether black lung disease is worth MSHA's efforts. But one cannot possibly look at the steep rise in the rates of the disease and conclude that black lung is not worth MSHA's efforts. One cannot hear Steve Day's heartbreaking story and the stories of other men and women who have suffered from this incurable disease and conclude black lung is not worth MSHA's effort. One cannot think about Steve Day's widow and the thousands of widows she represents and conclude black lung is not worth MSHA's effort. Mining is one of the most dangerous jobs in America, and the men and women who take on this work deserve MSHA's reasoned efforts to protect them against this horrible disease. Black lung disease is man-made, and we have the power to end it. More than a year after MSHA's new respirable dust standards went into effect, sampling results show that coal operators are complying with the rule and miners are better protected. The upcoming phases of the rule will do even more to protect miners. Most coal operators are deeply committed to the health of their employees and recognize their responsibility to care for those former employees with the disease. Unfortunately, some coal operators refuse to live up to that responsibility, choosing instead to use the medical and legal system to deny miners their deserved benefits. Steve Day's story brings to life the heartbreaking consequences of unfair tactics designed to release coal miner operators of their responsibility to afflicted miners. I thank the witnesses again today for being here and helping us better understand the obstacles claimants face in securing their benefits. We have to do better. Mr. Chairman, I know that you are just as committed as I am to protecting miners' health. So I hope we can find common ground and work to pass provisions in the Black Lung Benefits Improvement Act. I also want to thank the witnesses for their discussion on the legislative reforms needed to improve the Mine Act. As mentioned during our April meeting, I hope we can work together on needed improvements to the Mine Act. Thank you, and I yield back.
I thank the gentlelady, and I appreciate those remarks. I think we do certainly agree that this is an industry across the board, whether it be coal mining, and I've had the privilege of going down into underground mining operations on several occasions, including once with Mr. Maines. In fact, we drove past his house, boyhood home, on the way to that mine as we went down. And we saw families who have had their lives affected in a positive way from having mining operations there for generations and a continuous operation. But we've also had the opportunity to meet miner families who have now lost their occupation. And so there's that challenge we have as well. I've had the opportunity to be in surface mining operations in North Dakota, in the Upper Peninsula of Michigan, with coal, with metallic, non-metallic mines, also to be under the city of Detroit in its salt mines, a totally different operation, with gas-powered gators running around in that mine, not like you'd find in a coal mine. It's a diverse industry, and it's an industry that needs to work cooperatively with the regulator, but vice versa as well. There has to be a partnership. I don't know how in the world it can be moved forward in safety factors as well as the continuity needed for providing a secure industry without a partnership relationship, that a regulator looks to the best practices of industry, and the industry makes sure that its operations with as much as possible compliance from everyone in the industry, works together and to ferret out the bad actors that thankfully are far and few between. But when we look back at the impact of the Upper Big Branch, for instance, and now the industry that has taken over that and is struggling with the economy because of the challenges brought on by a bad actor, we need to make sure that we don't just step in with regulation, but we do it right-headed. And that's what I think the testimonies given today from all sides of the ledger will help us as we move forward, but move forward with a purpose in mind, that individuals, miners, families, and operators remain as the central focus for success in the industry, and ultimately then success for what they produce in the lives of the rest of us. So thanks again for the committee members, the staff, as well as those who've given testimony today for making this, I believe, a valuable hearing. No further agenda for the committee. With the bid in hand, I declare it adjourned.